Hello everyone, I welcome you all to this lecture. In this lecture, we are going to discuss the further part of Module 5. In the previous lecture, we have discussed the introduction of the IT Act 2000 with its aim and objectives. Also, we have discussed the scope of the Act. We covered some major concepts with their definitions and the important provisions. In this lecture, we are going to discuss the further part in the form of attribution, acknowledgement, and dispatch of records, and so on. Here, the meaning of attribution is uh, cyber attribution is the process of tracking, identifying, and laying blame on the perpetrator of a cyber attack on the or other hacking exploit. Cyber attacks can have serious consequences for businesses in terms of public relations, compliance, reputation, and finances. And acknowledgement is about the sent electronic record must be acknowledged, the sender or the originator and the recipient. And dispatch of electronic records, here this shows how the originator can able to send the electronic records. So here we can discuss these things in terms of three things: the attribution of electronic records and acknowledgement of receipt, time and place of dispatch and receipt of an electronic record. Before that, we had already know the electronic record that refers to any data or information or record or a data generated such as a text, image or sound, which can be stored, received, or can be sent in an electronic form or a computer generated microfiche like storage. That thing. Now, attribution of electronic records. An electronic record shall be attributed to the originator if it was sent by the originator himself or by a person who had the authority to act on behalf of the originator in respect of that electronic record, or by an information system programmed by or on behalf of the originator to operate automatically. It is according to the section L1. You can ignore the section numbers as with our syllabus. Just remember the meanings. And second one, acknowledgement of receipt, where the originator has not agreed with the addressee that the acknowledgement of the receipt of the electronic record be given in a particular form or by a particular method. An acknowledgement may be given by any communication by the addressee, or it can be automated or otherwise any conduct of the addressee sufficient to indicate to the originator that the electronic record has been received. Where the originator has stipulated that the electronic record shall be binding only on receipt of an acknowledgement of such an electronic record by him, then unless acknowledgement has been so received, the electronic record shall be deemed to have never been sent by the originator. Where the originator has not stipulated that the electronic record shall be binding only on receipt of such an acknowledgement, and the acknowledgement has not been received by the originator within the time specified or agreed. If no time has been specified or agreed to within the reasonable time, then the originator may give notice to the addressee stating that no acknowledgement has been received by him, and specify a reasonable time by which the acknowledgement must be received by him. And if no acknowledgement is received within the aforesaid time limit, he may, after giving notice to the addressee, treat the electronic record as though it has never been sent. And third one, time and place of dispatch and receipt of an electronic records. Unless otherwise agreed to between the originator and the addressee, the dispatch of the electronic record occurs when it enters a computer resource outside the control of the originator. Unless otherwise agreed between the originator and the addressee, the time of receipt of an electronic record shall be determined as follows. Namely, if the addressee has a designated computer resource for a purpose of receiving electronic records, receipt occurs at the time when the electronic record enters the designated computer resource, or if the electronic record is sent to a computer resource of the addressee that is not the designated computer resource. Receipt occurs at the time when the electronic record is retrieved by the addressee. If the addressee has not designated a computer resource along with the specified timings, if any, receipt occurs when the electronic record enters the computer resource of the addressee. Unless otherwise agreed between the originator and the addressee, the electronic record is deemed to be dispatched at the place where the originator has his place of business, and is deemed to be received at the place where the addressee has his place of business. The provisions of some sections shall apply, notwithstanding that the place where the computer resource is located may be different from the place where the electronic record is deemed to have been received. For the purpose of this section, if the originator or the addressee has more than one place of business, the principal place of business shall term the place of business. If the originator and the addressee does not have a place of business, his usual place of residence shall be deemed to be the place of the business. Usual place of residence in relation to a body corporate refers to the place where it is registered. This is about the attribution, acknowledgement, and dispatch of an electronic records. Now we'll see this how we can have the secure electronic records and secure digital signatures in the form of three things: secure electronic record, secure digital signatures, and the security procedure. First one, secure electronic record. Where any security procedure has been applied to an electronic record at a specified point of time, then such a record shall be deemed to be source electronic record from such a point of time to the time of verification. Next one, security digital signature. We already know that digital signature is the digital code where the sender will be using his private key to digitally sign over the particular document which is electronically transmitted and which can be later submitted to the receiver, and he will be using the public key of the sender to read the message contents, and that is also checking the authenticity. So here secure digital signature, if by an application of a necessary procedure agreed to by the parties concerned, it can be verified that a digital signature at the time it was affixed was unique to the subscriber affixing it, capable of identifying such a subscriber, created in a manner or using a means under the exclusive control of the subscriber, uh, and it is linked to the electronic record to which it relates in such a manner that if the electronic record was altered, the digital signatures would be invalidated. Then such a digital signature shall be deemed to be secure digital signature. This is about the electronic record and the digital signature security along with the security procedure. Let us have the further discussion in the form of regulation of certifying authorities. So here in this section, we are going to discuss the regulation applicable to the certifying authorities, and hence the appointment of controller and other officers by the concerned authorities. So here we are going to discuss it in the form of the 17 points. Just I listed the points from 1 to 17 here. So let us have the quick discussion on each of these points. The first one, functions of controller. Here the controller meaning is the controller is a person or a network administrator, administrator to a system that will act as a repository of all digital signature certificates under the Act. Uh, this controller will make use of secure hardware, software, and also procedures, observes the standards that the central government prescribes to ensure the secrecy and also the security of digital signatures. Now, the first one is uh, appointment of controller and other officers can be done by the central government as an authority. The central government may, by notification in the official gazette, appoint a controller of certifying authorities for the purpose of the act, and may also, by the same or subsequent notification, appoint such a number of deputy controllers and assistant controllers as it requires. The controller shall discharge his functions under this act subject to the general control and directions made by a central government. The deputy controllers and assistant controllers shall perform the functions assigned to them by the controller under the general superintendents and the control of the controllers. The qualifications, experience, and the terms and conditions of service of controller, deputy controllers, and assistant controllers shall be such as may be prescribed by the central government. The head office and the branch office of the controller shall be at such places as the central government may specify, and also these may be established at such a places as the central government may think fit. There shall be a seal for the office of the controller. Now let us see the functions of the controller. Uh, the controller may perform the things such as exercising the supervision over activities of the certifying authorities. A controller can certify public keys and certifying authorities, laying down the standards to be maintained by the certifying authorities, specify the qualifications and experience that which employees of the certifying authorities should possess, specifying the conditions subject to which the certifying authorities shall conduct their businesses, specifying the contents of written, printed, or visual materials and advertisements that may be distributed and used in respect of digital signature certificate and the public keys. Specify the form and content of digital signature certificate and keys. Also specifies the form and manner in which the account shall be maintained by the certifying authorities. The controller may also able to specify the terms and conditions subject to which the auditors may be appointed and the remuneration to be paid to them. Controller is responsible for facilitating the establishment of any electronic system by certification authorities either slowly or jointly with other certifying authorities and the regulation of such systems. Also able to specify the manner in which the certifying authorities shall conduct their dealings with the subscribers. The controller can resolve any conflict of interest between the certifying authorities and the subscribers, laying down the duties of the certifying authorities, maintaining a database containing the disclosure record of every certifying authority. So these are the functions of controller. Moving on to the next point, recognition of foreign certifying authorities. The controller may, within the with the previous approval of central government and by notification in the official gazette, recognize any foreign certifying authority as a certifying authority for the purpose of the act. Where any certifying authority is recognized, the digital signature certificate issued by such certifying authority shall be valid for the purpose of the act. The controller, if he is satisfied that any certifying authority has contravened any of the conditions and restrictions subject to which it was granted recognition, for reasons to be recorded in writing by notification in the official gazette, revoke such recognition. And next, controller to act as repository. The controller shall be the repository of all the digital signature certificates issued under this act. The controller shall make use of the hardware, software, and procedures that the secure against the intrusion and the misuse. The controller shall observe also some standards as may be prescribed by the central government to ensure that the secrecy and security of the digital signatures is assured. The controller shall maintain a computerized database of all public keys in such a manner that such a database and the public keys are available to any member of the public key usage. Next, license to issue digital signature certificates. Having digital signature certificates, it is necessary to digitally sign a document. A digital signature certificate contains what is known as a key pair comprising private key and a corresponding public key. The private key is to be maintained securely and confidentially. The public key is shared with the receivers of a document. In India, the government via the controller of certifying authorities. Any person may make of an use of an application to the controller for a license to issue the digital signature certificates. No license shall be issued unless the applicant fulfills such requirements with respect to the qualification, expertise, manpower, financial resources, and the other infrastructure facilities which are necessary to issue such digital signature certificates. A license granted can be valid for such a period as may be prescribed by the central government, and the license grant is said to be it is not transferable or heritable, and this license may be subject to the terms and conditions specified by the again the regulations. Next one, application for license, fifth point. Every application for issue of license shall be in such a form as may be prescribed by the again the authority central government. Every application for issue of a license shall be accompanied by a certification practice statement, a statement including the procedures with respect to the identification of the applicant, payment of such fees not exceeding 25,000 as may be prescribed by the central government, such other documents as may be prescribed by again the same authority. Renewal of license. An application for renewal of a license shall be in the required form and which must be accompanied by the fees not exceeding rupees 5,000 as may be prescribed by the central government and shall be made not less than 45 days before the date of expiry of the period of the validity of the license. Next one, procedure for grant or rejection of license. The controller may, on receipt of an acknowledgement under the section, after considering the documents accompanying the application and such other factors as he deems fit, grant the license or reject the application. In suspension of license, the controller may, if he is satisfied after making such inquiries, he thinks that a certifying authority has made a statement in or relation to the application for the issue or renewal of the license which is incorrect or false, and the authority has also failed to comply with the terms and conditions subject to which the license was granted, and also failed to maintain a standard specified under some clauses of a section, and maybe contravened any provisions of the act, rules, regulation, or order made thereunder, revoke the license. The controller may, if he has reasonable cause to believe that there is any ground for revoking a license, by order suspend such a license pending the completion of any inquiry ordered by him. No certifying authority whose license has been suspended shall issue any digital signature certificate during such suspension. Next point, notice of suspension or revocation of license. Where the license of the certifying authority is suspended or revoked, the controller shall publish notice of such suspension or revocation as the case may be in the database maintained by him. Where one or more repositories are specified, the controller shall publish notices of such suspensions or revocations as the case may be in all such repositories. Next, next point, power to delegate. uh, the controller may, in writing, authorize the deputy controller, assistant controller, or any officer to exercise any of the powers of the controller under this chapter. So, power to delegate is where the controller can give his charge to the deputy controllers or the assistant controllers or any other officer to exercise any of the powers of the controller. Power to investigate contraventions. The controller or any officer authorized by him in this behalf shall take up for the investigation any contravention of the provisions of the Act, rules, or regulation made by thereunder. The controller or any officer authorized by him in this behalf shall exercise powers like those which are conferred on income tax authorities under the Chapter 13 of the Income Tax Act 1961. Next, access to computers and data without the prejudice to the provisions of the section 69. The controller or any person authorized by him shall, if he has reasonable cause to suspect that any contravention of the provisions of this act, rules, or regulations made thereunder has been committed, have access to any computer system, any apparatus, data, or any other material connected with such system for the purpose of searching or causing a search to be made for obtaining any information or data contained in or available to such computer system. For the purpose of the section 1, the controller or any person authorized by him may by order direct any person in charge or otherwise concerned with the operation of the computer system, data, apparatus, or material to provide him with the such reasonable technical and other assistance as he may consider necessary. It is under the section 29. Next, certifying authority to follow certain procedures. Every certifying authority shall make use of hardware, software, and procedures that are secure from the intrusion and the misuse. And the certifying authority must provide a reasonable level of reliability in its services which are reasonably suited to the performance of intended functions. And they must adhere to security procedures to ensure that the secrecy and privacy of the digital signatures and its assurance. And certification authorities shall responsible for observing uh, other standards as may be specified by the regulations. Next point, certifying authority to ensure compliance of the act. Every certifying authority shall ensure that every person employed or otherwise engaged by it complies in the course of his employment or engagement with the provisions of this act, the rules, regulation, and order made thereunder. This is according to the section 31. And last, next one is display of license. Every certifying authority shall display uh, its license at a conspicuous place of the premises in which it carries on its business. And next, surrender of license. Every certifying authority whose license is suspended or revoked shall immediately after such suspension or revocation surrender the license to the controller. Where any certifying authority fails to surrender a license, the person in whose favor a license is issued shall be guilty of an offense and shall be punished with an imprisonment, which may extend up to 6 months or a fine amount up to 10,000 rupees, etc. And last one, disclosure. Every certifying authority shall disclose the manner specified by the regulations. Its digital signature certificate, which contains a public key corresponding to private key, and any certification practice statement relevant to the thereto. And the certifying authority shall disclose the notice of the revocation or the suspension of its certifying authority certificates and any other fact that materially and adversely affects either the reliability of a digital signature certificate which that authority has issued or the authority ability to perform its services. And in opinion of the certifying authority, any event has occurred or any situation has arisen which may materially and adversely affect the integrity of its computer system or the conditions subject to which a digital signature certificate was granted, then the certifying authority shall use reasonable efforts to notify any person who is likely to be affected by that occurrence or can act in accordance with the procedure specified in its certification practice statement to deal with such event and situations. So these are the terms which you have to understand about uh, the regulations of a certifying authority. Thank you.